Miss Batcher, before we get underway and before you even do the introductions, could I emphasise to everybody that it seems to us that all the, not only all the children, but all the individual parties in this case are entitled to anonymity in the sense that they shouldn't be referred to by name in oral argument. That doesn't, of course, apply to the county council, but it does apply to everybody else, not just Child G, but all the others as well.
My Lord, we've had those discussions outside of court this morning. We were proposing to stick to the previous appeal alphabet for the children, so Child A being the eldest child of the family within these proceedings, going through to the youngest child, Child F. Child G we're going to refer to as non-subject Child G, so that's absolutely clear who that child is. Mother we were simply going to refer to as mother. And the relevant father we were going to refer to as Mr. M.
Yes.
I think that's slightly easier.
Yes.
Right.
All right. Thank you very much. Now over to you to do the introduction.
Thank you. My Lord and Lady, I appear on behalf of the local authority. At the back of the court I have the allocated social worker, Miss Ansell. Next to me is Miss Beer, who represents Mr. M, who sits at the very back. We've placed Miss Beer next to me, given that the appeal really affects her client, and so she's effectively the first respondent rather than the mother. The mother is represented by Miss Grieve. Mother is not in court. We then have Mr. Keys at the back, second row, who represents father of Child E. And we have Mr. Singh, who represents the father of children C and D. And then we have Miss Muse, who represents the guardian, Miss Valentine. We also have at the back of court Miss Ashby, whose position statement should have come through to
on behalf
of Child C,
Yes.
who is now separately represented.
Yes.
Just so I'm clear, although everybody's entitled to be here, am I right? We're only going to get representations from 4.
Yes.
That's right. So it's washing briefs for the others. Is that right? Good. Thank you.
Yes. Yeah. My Lord and Lady, you all have the benefit, I think, of the 4 detailed skeleton arguments, and those are the appellants and respondents who are going to be making submissions to you in respect of the appeal.
Yes. And it seemed to us, unless any of you feel strongly to the contrary, that the natural batting order would be the council, children's guardian, mother, Mr. M.
My Lord, I have no difficulty with that.
My Lord, I think if we just switch mother and Mr. M in that batting order. So,
all right. Mr. M first and then the mother.
Then mother.
All right, that's fine.
Yes, fine.
Yes.
I'm great.
Okay. Ready to go, Ms. Batcher.
Well, my Lords, on behalf of the local authority, I'm not going to repeat everything that's within my skeleton argument, but I do want to just draw the court's attention to a few points. First of all, you have the benefit of the very full skeleton arguments from all of the parties. We all agree on the law and the nature of the factors that the court and Judge Clarke had to take into account when considering the local authority's application for permission to rely on allegations and to seek to pursue those allegations within care proceedings relating to a child who was not subject to the proceedings. I have to accept on behalf of the local authority that one of the significant factors, of course, is delay.
Well, there's no prospect of this if we allow the appeal. Obviously, the case going ahead next week. If the appeal is dismissed, is the welfare hearing still up and running for next week or not? So just so we know what the consequences are, if we allow the appeal, what do you see happening after that?
If the appeal is allowed, the local authority would be asking for the matter to be sent to the liaison High Court judge for a directions hearing and a case management hearing, because we would then need to consider the interveners being invited and then the case management directions following from there for a...
Could that not be done by the judge currently allocated to the case?
It could, and of course we have the dates next week and the week after for that.
What are the advantages of sending it to? Is it Mr. Justice Newton, or is it Mr. Justice
I think it's Mr. Newton.
Hertfordshire? Mr. Justice Newton or Mr. Justice who is it? Williams.
No, Williams is Sussex.
No, it's Mr. Justice Newton.
Williams,
Mr. Justice Newton. Then, okay.
Yes.
So,
Yes.
why do you think it should go to him rather than stay with?
My
Judge
Lord, when we
Clarke?
look at what's likely to be involved if the appeal is allowed, and the local authority are allowed to put that schedule of allegations before the court, we have a non-subject child. There will need to be consideration of how the re-W principles will apply to that child, given that she's not subject to the proceedings, doesn't have a guardian in the usual course of events. We have 2, possibly 3 interveners. As I understand it, not having been involved in those proceedings relating to Child G, there are likely to be the need for intermediaries as well. My Lord, I would say on behalf of the local authority that those are all matters that make this a more complex
Case
case
management.
than normal. And so, in fact, Judge Clarke had invited the local authority to prepare a detailed position statement as to why it was that we thought the matter ought to be before a judge of the High Court of the Family Division. And we had understood that for the hearing in November, that position statement had been sent. I drafted that position statement. It had been sent but hadn't been read by Judge Newton. And so Judge Clarke, the original application from the local authority was to adjourn the matter to Judge Newton to consider all of matters, and Judge Clarke refused that application and dealt with the application for the local authority to rely on the finding, the schedule of allegations.
Well, we don't have to explore that further. There might be something to be said if the appeal is allowed for passing the baton to Mr. Justice Newton if he's the relevant liaison judge. But we'll see. Anyway, that's putting the cart before the horse, perhaps.
Yes.
The hearing that's booked for next week is what's the length of the hearing that's booked?
10 days.
10 days. Goodness. Right.
10 days on a welfare hearing.
Well, my Lord, it is 10 days. We have tried to case manage because, in fact, trying to deal with this particular issue, we had a number of hearings. I think we had about 4 hearings, 5 hearings, 2 before Judge Vavrechka, 3 before Judge Clarke, all of which dealt with trying to get the information and the evidence in relation to this issue. So although we had listed the final hearing, and I think we were originally listed in December and then it moved to the end of January due to the court's availability, the matter wasn't timetabled in terms of evidence. And so the parties have been trying very hard to make sure that if this appeal is not allowed, that we are in a position to put some evidence from all of the parties before the court. It's not ideal, I have to say. The local authority have filed their final evidence on the basis that without these allegations, I can update the court as to what the local authority's proposed care plans are if I'm asked to, but it's not relevant to the decision that Judge Clarke had to make. So although we are listed for 10 days, it was on the basis that it was going to be a heavily contested hearing. We really haven't, I have to say, given in the hearings that we've had in the lead up to the November hearing, given any thought to the final hearing itself. So that's why it remains.
But the issue at the next week, this is relevant, is the purpose of this appeal, just so we have an idea of the outline. It's proposed by at least some of the parties, is it, that all of these, or all or some of these children should be in the care of the mother and Mr. M?
Yes. If the appeal is not allowed, the result is going to be whether or not there is a supervision order with the children all remaining at home. At the moment, Mr. M is not in the property. His bail conditions have ended, but he has agreed, while this issue remains outstanding, to remain away from the home. The local authority are funding a hostel for him, and so he hasn't been in the home, but that will change.
So, if I got this right, all the parties are agreed that children, if we ignore these allegations, all the parties agree that these children should be at home with the mother. Is that right?
Yes.
And the only question is whether there should be a public supervision order.
I have to be fair to the Guardian, who hasn't yet filed her final recommendation.
Subject to the Guardian, at the moment,
the local
you're
authority,
saying supervision order,
the local authority care plan is for no orders. There are reasons for that in terms of cooperation and whether we think that they would be workable.
And the family and who's asking for supervision order then?
The Guardian's likely to be asking for a supervision order.
10 days, Ms. Beckham.
Well,
I know this isn't before us. I'm horrified at the idea of 10 days on that issue.
Well, look, to be fair, the local authority only filed their final evidence last week.
Okay.
So it's quite clear now, and we've been discussing a consent order to reduce the timetable, because we clearly aren't going to need 10 days, not on the local authority's care plan. But of course, my Lord, if I come back, because the difficulty the local authority have is without permission to be able to pursue these allegations, that is the position the local authority are left in, having nothing else to put before the court in terms of the issues of risk to these children who are likely to remain at home. And that really is the nub of the point that we were making to Judge Clarke. It's the essence of the allegations when we look at them, and the essence of the issues before any judge at welfare, in considering not just His Honour Judge McPhee's findings both at the welfare hearing, which were not disturbed by the Supreme Court, but also in the December 2020 fact finding. But when we look at all of the previous judgments, what is abundantly clear is that the one thread of risk to these children is that of sexual risk. There are threads throughout the proceedings. And so for all of the childcare professionals involved, being asked to make recommendations for these children, knowing that there are very detailed allegations made by a child who knew this Father M, who has a half-brother through Father M, through her mother. It's an unrealistic and uncomfortable position that the childcare professionals are left in having to make those recommendations. My Lords, I know that you gave leave to the report of Mr. Lowe to be in this bundle. It, of course, wasn't before Judge Clarke. I think it was a few weeks away from being completed. We have that report now. I would say that on behalf of the local authority, there are real concerns raised within that report. All of the information that's within this bundle, the police evidence, was sent to Mr. Lowe as soon as it was received, and that was on direction of the court and by the agreement of all parties. But it's quite clear from Mr. Lowe's report that he has really not delved into the impact that those allegations, if they are true, could have on the matters that he was being asked to assess. And of course he was being asked to assess whether or not Mr. M was a protective factor, which meant that these children could remain within the home. My Lords, I just want to just have a very brief look at the allegations, because these are not allegations. Somebody who has known Mr. M briefly, who has made an allegation, for example, and I'm not dismissing what I'm about to say, but this is not the lower end of, for example, domestic violence. These are extremely serious, detailed allegations of sexual abuse by 4 adults on a very young child. It's not a matter of whether or not the local authority believe non-subject child G. That's irrelevant. It's the impact, if they are true, on the children who are subject to these proceedings. And it's the impact of not investigating within these proceedings, but having a situation where these children remain at home, whether under a supervision order or whether under no orders. And when we look at the history of this case, the reality of matters coming back before the court under separate proceedings, because that is what has happened with this family repeatedly. And so the local authority are really concerned about making recommendations without being able to investigate these matters. And it's difficult to see how the court can make decisions on all of the recommendations that will be before the court and the positions of the parents without knowing the truth or not of those allegations. This is not a situation where we can try and resolve matters with admissions, because when we look at the difference between the position of Mr. M and of what is said, we are as far apart as we can be. Miss Beer's skeleton arguments, and it's at A79 of the bundle, is clear that Mr. M's position is that he left before non-subject child G was even born. He has not played a stepfather role for her. He doesn't know what she's talking about. That is the plank of his position. But when we look at her ABE, and that's B6, 7 onwards, when the police are asking non-subject child G about the family composition, she starts off with her parents, she starts off with her grandparents.
Sorry, what page?
It's B267.
Oh, right. So in the
Appeal bundle.
yes, this is the second volume of the appeal bundle. Is that right? D267.
No, B.
And
B.
These are documents. I asked questions. I'm very grateful to your solicitor, issued in court, Ms. Benson, for answering my.
It's Ms. Page, it's paralegal.
Okay, but whoever answered the questions, I'm very grateful to them for answering my questions. I wasn't clear on what had been disclosed, because some of these documents have not been disclosed to some of the parties.
Yes.
And these are the this
Yes,
includes the documents we're
that's
now
right.
looking at.
Well, I'm sorry, I think I have the full bundle, so I don't have the...
No, well, we didn't have a Judge Favretchka's disclosure order, so
Yes.
I was concerned that we
dealt
were
with
going
it
to be.
yesterday.
Yeah, thank you very much for dealing with that. So 267.
267 onwards, but in particular, it goes over the page. It's important, I say, to read all of 267 and 268, because what is absolutely clear towards the bottom of 268 is when she is asked about somebody that she had referred to.
We have. I mean, we've got this
There's
in
a B28.
We've also got it in earlier on in the first volume of a B25, haven't we?
You may have. I'm
Is there a difference?
Well,
No.
there's not, because they're both with that.
No.
It does look like the same interview.
It's
20th
repeated
September.
twice. The interview is repeated twice. within the bundle.
Well, why don't you tell us? I think we've all been working on the first one we came across in the bundles. What internal page number is it? 7? 4.
Give me a moment and I'll go to the right page on.
Internal 4, B28.
It's B29, B28 and 29.
Right. Yes.
What we see at the bottom of B29 is when she's asked specifically about the person that she refers to as her stepfather, stepdad, She gives a very clear explanation. This is not somebody that she vaguely remembers.
I mean, the names are all redacted, but if is it Mr. M whose
It can
name
only be Mr. M.
is Mr. M? Have you seen the unredacted
Yes.
document? And it
Yes.
is. It does.
Yes.
Refer, it is Mr. M who is named.
It is. So he is named in the pre-assessment
Okay, fine.
and referred to as the stepdad in that as well. And so, really, I come back to the point that this is not a situation where we can try to deal with matters by either having some admissions or asking Mr. Lowe to take into account certain matters that Mr. M may be able to make some minor admissions to. It's a yay or nay situation. These allegations are either true or they're not. And the impact is so significant, local authorities say, on the outcome for the subject children that the childcare professionals are not, should not be placed in a position, and the court should not be placed in a position where we are having to put them to one side to be able to make recommendations for these children and ultimately decisions for these children. So on that basis, on behalf of the local authority, I say that Judge Clarke was wrong, plainly wrong, to say that that there are situations involving allegations of this length, breadth and detail that can be in the background when a court is being asked to make final welfare decisions about children, when the central thread of those allegations relates to the central thread that that court is being asked to make decisions about.
Now, there are really 3 points, probably more, but 3 particular points which are made against you. First is this is a case management decision, and this court should be reticent about disturbing that. The second is that this case has already been going on for, is it 2 years, nearly 3 years, and that to add a further delay of months, at least months, several months, would be contrary to the children's welfare. And the third is the judge's evaluation of the likelihood of the allegations being established.
Well, I have to accept the delay point because there's no doubt that this is the case that has had significant delay. The simple point I submit in relation to that point is that the nature of the allegations is so central to the risks to these children going forward that it is a balancing exercise, of course, between the delay and whether or not we pursue these allegations. But if we don't, there is a real likelihood that we will be back before the court under separate proceedings. And of course, by that stage, it's too late because the damage to the children is likely to have happened already. That's why we would be back in proceedings, because there would be concerns. And that is what we have seen throughout with this family. And I come back to the many judgments that we've had from Judge Wright, from Judge McPhee, we say going forward, there is no confidence that the parents, in particular the mother, has taken on board and learnt, and there is no confidence that Mr. M is going to be the protective factor, as Judge McPhee thought he might be, and which we say Mr. Lowe has not properly assessed. And he can't assess without knowing the factual matrix for these particular allegations. My Lord, in relation to the other points, which I'm afraid have just escaped.
Well, the first is sort of rhetoric, really. It's a case management decision. Second is delay, you've dealt with that. The third is the judge's view of the likelihood of the findings being
well, my Lord, Judge Clarke hadn't read or seen the ABE interview.
Had he not read
No.
the transcript?
No,
Yeah, I know he hadn't seen it, but he hadn't read it.
no. He, it was quite clear, I say, that he had not looked at the police disclosure in its entirety, and at the very least had not read or seen the ABE interview or the pre-assessment interview, both of which the local authority say are compelling reading and have led to the local authority seeking to put these allegations before the court because of the length and breadth and the detail within those two particular documents.
In your opening remarks and throughout, you've been referring to the impact of these allegations, if true. That may well be the right approach. Paragraph 28 of the judgment appears to record that it was common ground, and something Miss Beer relies on, common ground that the court was entitled to look at the likelihood of the allegations being proved. Now, is that the correct approach? Or was the judge really entitled to look at the likelihood of the allegations being true?
Well, my lady, I say that the judge was entitled to look at the likelihood on a far more superficial level than delving into the details, because, of course, at that point, the information before the court and the parties would have been the ABE interview, the pre-assessment interview, and only the police disclosure. Now, Miss Beer and I both had the benefit of having had some of the previous papers, but the parties didn't have those, and the court certainly didn't have those. And so, for His Honour to be making decisions as to the likelihood of the local authority proving, or being able to prove for certain those allegations was the wrong approach.
Because you could put it the other way and say, unless the judge was able safely to take the view that there was no prospect, nil prospect,
Yes.
of these allegations being proved, he had to look at their impact if true.
Well, my lady, I think you put it far more eloquently than I have tried to put it, but that's precisely the point. What the local authority say is that when you look at the pre-assessment interview and the ABE interview, there is enough there to be able to say that the local authority may be able to prove the allegations. To simply say that it was unlikely that we were going to was the wrong approach. And certainly without having even looked at those documents.
That's a separate but additional point.
Yes,
effectively.
but a really concerning point on behalf of the
Understand.
local authority.
You said that the judge thought that it was unlikely that the local authority would be able to prove the allegations for certain. Is that the way he put it?
No, he didn't use the word certain.
It would be a question of balance of probabilities at the actual hearing, if there was one, wouldn't it?
The reason that I use the word certain is because when we look at what Judge Clarke was considering, including asking the local authority to answer the question of what powers he had to order a physical examination of non-subject child G, because that, in his mind, would add to whether or not these allegations were true. It is what I say lends weight to the point that His Honour Judge Clarke was looking at this from the wrong point of view and was looking at it from whether or not the local authority could certainly prove these allegations.
The prospects of the allegations being proved, on which you all agree was something the judge could look at.
Yes.
I'm hesitant about wading in detail into the case law on the factors, about which there's been quite a lot of recent jurisprudence. But looking at Mr. Justice McFarlane's, who then was list in the DP case, which is at C6 in the quoted by Lord Justice Peter Jackson in HDH, paragraph 16. C6 in the authorities bundle. I don't see prospects of the allegations being proved as being a factor. Is it? Lord Mr. Justice McFarlane said, interest of the child, the time the investigation will take, the likely cost of public funds, the evidential result, necessity or otherwise of the investigation, the relevance of the potential result of the investigation to the future care plan of the child, the impact of any fact-finding process upon the other parties, the prospects of a fair trial, the justice of the case. I don't know whether the evidential result is a factor, which means prospects of success. Perhaps it does.
Well, my lord, I would say that that certainly has to be one of the encompassing factors within all of those particular factors, because if the local authority were presenting a situation where there was a non-subject child who was making some vague allegations, that's a very different situation to what we have before.
I think that's
in this.
quite dangerous, speaking for myself, because what you can't have, certainly in different contexts, is a mini trial. So I'd be interested in this position that it's either there's no real prospect, or once you're over that threshold, it's not appropriate for the court to start looking at the relative merits and demerits.
Well, the difficulty, my lady, with that point is that the court can't start delving into the merits in its entirety, because all of the evidence is not before the court at that point. And that's the point of having then the further case management hearings in order to have the rest of the evidence before the court. So what I say Judge Clarke was wrong on was taking into account the factor of the whether or not the local authority were likely to prove these allegations, not having had a look at the evidence that was before the court, i.e. are these very vague allegations with hardly any substance to them, or is there enough there for the local authority to say that not only is there enough here, but it's relevant to the issues before this court?
It would be odd, speaking for myself and not an expert in this field, it would be odd if there were no threshold at all, but you say if there is a threshold, it's quite a low one.
At that point of the proceedings, absolutely.
Yes, as to whether to conduct the fact.
Yes.
Other areas of the law, there's the concept of a serious question to be tried. And if there's no serious question to be tried, it's difficult to see why all this would be put underway. But
if you look at how Lord Justice Peter Jackson developed Mr. Justice McFarlane's criteria on C9 under Roman 8 in paragraph 22, under the justice of the case, he says, line 5 of that subparagraph, the level of seriousness of the disputed allegation may inform this assessment, which is really the point my Lord and my Lady are making, I think. So that's where that comes in.
Yes. But my lords,
But the prospects of success is
not a factor in itself.
no, it's quite a difficult thing
Yes.
to assess without accurately.
Without all of the evidence. And the courts are, in every situation where there is a possible fact-finding, are faced with the situation of not having the evidence before it until after the schedule has been compiled.
And you also have the point the judge didn't, you say didn't look at the evidence.
No. But that was there, which we say was enough to be able to allow Judge Clarke to see the link between the allegations and the issues that he was going to be asked to determine at welfare.
The judge may not have all the information at this stage. I mean, you have here a lot of information, but the allegations might be made and the judge might have to make the decision before all the evidence is available. There might not even be an interview, or there might be no further investigations carried out.
Well, my lord, the difficulty that the local authority found with the ultimate decision of Judge Clarke was that we'd had 4 case management hearings in order to have the evidence before the court so that that decision could be made. And so not only was it surprising and concerning that the evidence hadn't been looked at, but to then say that it could be, that final welfare decisions could be dealt with those allegations remaining in the background. And I accept on behalf of the local authority that there are sometimes situations where very, very low level allegations are made within proceedings that are not going to be litigated because they're not relevant to the welfare decisions that the court has to make.
That's really the point
that
Lord Justice Peter Jackson makes in point 8. The extent of any gulf between the factual basis for the court's decision, with or without a fact-finding hearing, the level of seriousness of the disputed allegation may inform this assessment.
And that's precisely the point in this appeal for the local authority. Can I assist any further? I appear to be at risk of repeating the points on behalf of the local authority.
Thank you very much. Miss Muse?
My lords, my lady, it will be apparent that the Guardian was very concerned about the prospect of delay. Her position when this case came to the Court of Appeal last year and her position in the Supreme Court was really predicated on her concern as to the impact of the delay on the children and the parents. So she's very alive to that difficulty. But we say on behalf of the children that His Honour Judge Clarke...
Sorry, you're whispering.
Sorry,
Muse,
forgive me.
Can you just speak up?
Forgive me, that His Honour Judge Clarke was wrong in reaching the decision that he made, and that when considering the case management decision that he had to make, he failed to properly take into account all of the factors that he should have taken into account. And I will take you to the most significant ones in the moment. I was not present at court on the 3rd of November. I'm not sure whether I would have agreed that it is a relevant factor for the court in the exercise of its case management discretion to consider the likelihood or otherwise of those allegations being proven. My lords, my lady, I would have really emphasised the matters set out in Lord Justice Jackson's judgment in HDH, some of which we submit were totally absent from the judge's consideration. There is an over-emphasis, we say, on delay, complexity and cost. And there is no balance when considering the impact on delay as to the serious nature of the allegations and the relevance to those allegations, to the welfare of the children in this case, and the relevance to the outcome of the hearing. His Honour Judge Clarke completely, we say, ignores those matters. And as my learned friend from the local authority says, the issue of child sexual abuse, risk of child sexual abuse and the ability to protect has been the central thread throughout all of the proceedings. has been a central thread of concern going back for over 20 years in this family.
I'm not surprised the judge was concerned about delay, and no doubt had in his mind everything that's been said by the senior judiciary, in particular the president, recently about delay in these proceedings, cost.
But, my lord, of course, concerns about delay and cost must not overtake the central issue of deciding a case fairly, justly, with the welfare of the children and the outcome at the centre. My lord, the Family Proceedings Rule 1.1 and 1.4 does not... Family Proceedings Rules 1.4 is there as an aid in the exercise of 1.1 as to how a case should be...
But delays, the court is obliged to have
Of course.
under statute
Of course.
to the impact of delay.
And as I hopefully outlined, the Guardian was very alive to that. But delay is not the only factor. And when considering the delay, one has to balance that against the risk to these children should the allegations be proven. Because what is being contemplated is placing very vulnerable children, some of whom have already been found to have been abused, all of whom have been found on more than one occasion to be at risk of child sexual abuse, and all of whom have had findings that they were not protected by their mother and not protected by Mr. M. The work that was carried out by the Lucy Faithfull Foundation and by Mr. Lowe was predicated on the basis that Mr. M had failed to protect, not on the basis that he was a potential perpetrator of abuse. If he is a perpetrator of abuse, then plainly the work that was carried out on a false premise. But most importantly, if he is a perpetrator of abuse, the children would be at it's plain, enormous risk. It's unlikely, we would say, that the children would be able to voice any concern, because you will have seen, certainly from the pre-assessment interview, or the police interviews with the children, they are very, very wary of authority. They are very conscious of the fact that the local authority have wanted to remove them. They are not going to tell anyone if anything untoward is happening in the home. We already have evidence of concern, recent concern about child. I'm going to get the
One of the children.
D. Behaving in a concerning way in terms of explicit photographs being shared with others. We have allegations going back 10 or more years in relation to the other children making comments about inappropriate things happening to them. Certainly the Guardian's view is that these children are not, at the stage they're at now, going to say anything to any professional explicitly. But we do have, in recent times, very concerning behaviours, certainly on the part of child D. And it's difficult, we say, to imagine what could be more relevant than these allegations. they go to the absolute core of the issue and the issues relating to protection. So when looking at necessity, when looking at the necessity of the investigation, we say it's absolutely crucial. Before any welfare decision can be made, the court needs to know, insofar as it possibly can, whether Mr. M is a perpetrator of child sexual abuse. Plainly, if he is, there would be a very different care plan and outcome for the subject children. And as I think I've outlined, we say that His Honour Judge Clarke completely ignored those factors and concentrated on delay, complexity and cost. And he was also unduly preoccupied, we say, with the notion that the prospect of the allegations being proven were low. And my lords, my lady, I agree with my lady's formulation that wasn't the correct way of looking at it, and if relevant, the threshold criteria in terms of the likelihood of any allegations being proven is very low. And further, we say that his reasoning in deciding that there was a low prospect of success was also flawed, because he focused on, one, the fact that the allegations related to a period of 7-8 years before, so they were historic allegations, and he focused on the notion that there was no medical evidence, and we say both of those, that he was wrong to focus on those matters, because my lord, my lady, you will be aware that up and down the country every day the family courts and the criminal courts deal with historical allegations of child sexual abuse, and the fact that they were historical are not in themselves, we would submit, they were barely relevant. Again, he was wrong, we say, to focus on his view that there was no medical evidence. Again, up and down the country every day the courts hear allegations of sexual abuse where there is no medical evidence. And my lords, my ladies, I've included short extracts from the Purple Book, which I know certainly my lord will be very well aware of, that there is often no evidence, medical evidence, even when examinations are undertaken within very short time after the alleged abuse. What he didn't look at all, which we say was highly relevant, was the police material. Not only the ABE allegations, the ABE interview, which we say sets out very clear, graphic, and the Guardian believes cogent evidence, the pre-assessment interview, or the information from the child's key worker, which I'd invite my lord, my lady to look at, which you will find at, certainly in my bundle, B438. We say that that is also key information. The child's worker sets out in detail and graphic terms.
Does this predate the ABE interview?
It does.
So it's
And I'm
first.
told that it was before His Honour Judge Clarke, or certainly available to His Honour Judge Clarke, but he didn't look at it. So this is the description of the initial allegation to the key worker in the children's home. But I'd invite you to carefully look at that. And we say it's quite astonishing, really, that having decided he needed to look at the prospects of success, that he failed to look at key material, the pre-interview assessment, this information from the key worker, and the ABE interview.
Do we have the pre-interview assessment?
You do.
I'm not suggesting that
You will find that at
B149.
B149. Thank you. Can I be of any further assistance?
Not to me. No, thank you very much.
B149 goes on. There are two documents that both relate to each other, so that when you get to the end of B149, there is in fact another document to go with it. It follows on.
Thank you very much. Miss Beer.
My lord, my lady, before going into the grounds, I'd like to just make a few general points. First, of course, being that this was an extempore judgment, it was at a hearing with a time estimate of 1 hour, and a longer hearing was not sought by the local authority. It was, as my lords, my lady have already pointed out, a case management decision made by an experienced family judge, which should cause this court to pause before interfering with that judgment. One brief administrative point, there is an error in the chronology. It's at B460. Unfortunately, I picked it up after the bundles had already gone in, and trying to correct those, I think, would have been more complex than making this correction now.
All right, let's do it now. 460.
B460. There's a reference to Mr. M's relationship with the mother of child G, ending in 2016. It's accepted by all that that's an incorrect date. It was 2008 that relationship ended.
8.
Yes.
Okay.
With that correction made, my lord, my lady, I go on to my general points that the court, in making a case management decisions about which issues and allegations should be litigated, have to make the decision of whether it is necessary, and that assessment is a discretionary one for the judge. The argument put before you by the local authority and the Guardian, when distilled to its essence, is that whenever serious allegations are made in care proceedings, which, if proved, would have an impact on the welfare determination, they must be litigated. And that position would, in our respectful submission, defeat the whole purpose of the court having a discretion. If a discretion can only be exercised in one way where there are serious allegations, then the existence of the discretion itself is rendered nugatory. This judge, we say, made a reasoned case management decision, exercising a discretion of the sort that Lord Justice Jackson noted in re HDH. It's at paragraph 23. The reasoned case management choice of a judge who approaches the law correctly and takes all relevant factors into account will be upheld on appeal unless it has been shown that something has gone badly wrong with the balancing exercise. It's accepted that His Honour Judge Clarke was not referred by any of the parties present at that hearing. I think myself and Miss Batchelor were the only two advocates who were present at that hearing to Oxfordshire or HDH in coming to these decisions. So his judgment naturally doesn't follow the structure of Oxfordshire or Oxfordshire as amended in HDH. But what we say is, in considering the relevant factors set out at 1.4 in the family procedure rules, which were read into the HDH, he in fact did cover all the relevant factors in coming to his decision. My lords, my lady, you have my skeleton argument, and I don't intend to rehearse that, but I would like to look at the local authority's grounds
Yes.
and respond in terms of those.
Have I got this right, that you accept that the factors set out in HDH are the right ones which should have been, you say, were applied?
My lord, I think we are bound by re-HDH.
Yes. Right.
So, although the judge was not directed to it, what we say is he did, in fact, through the prism of Rule 1.4, actually in his judgment cover all the relevant factors. And of course they are non-exclusive factors, and it's very clear that not all of them are relevant in each case.
Yeah. You're going to say something, are you, about whether the prospects of success is a factor?
Yes, I think with your permission, my lord, I will come on, as we deal with the grounds. Ground one of the local authority is that the court did not give sufficient weight to the arguments put forward by the local authority and endorsed by the Guardian that the investigation and findings were necessary. And what we say is His Honour Judge Clarke did in fact deal with the necessity point. It's at paragraph 28 in his judgment. He has to make that assessment of necessity.
Page?
Let me just find that for you, my lord. It is B100. As far as the allegations are concerned, this court...
Well, the word necessary doesn't appear in that.
No, but it deals with the topic of necessity effectively.
How?
Because it is balancing the requisite factors and looking at whether or not a fact-finding should be put in place. He goes on again at 33 to say that he cannot see that because an allegation has been made, that in itself there has to be a finding on it.
But he wasn't looking, on the face of it at least, at the necessity of resolving these issues in order to arrive at the right result at the end of the day, was he?
Well, he sets out, and it's at 30 in his judgment, the basis of his decision. And he says that in all the circumstances and having considered all of the matters, taking into account the likely impact, taking into account the severity of the allegations, but taking into account the likelihood that the local authority will be able to prove such allegations, the court is not satisfied it would be appropriate to give the local authority permission to pursue those allegations. So,
Can I just test your argument this way, if I may, Miss Beard? If the allegations are not true and ignored,
yes.
then it seems to be the case that all parties are agreed that the children should remain at home, that Mr. M should have unrestricted contact and would have a role in protecting the children.
Yes.
And the only question is whether there should be an order.
That is correct. However, the nuance to that is that there is a safety plan that has been drawn up by the mother and Mr. M, together with the expert Steve Lowe. It's in the bundle. It looks at the fact that these would remain unproven allegations were the final hearing to continue next week, and the local authority's position or the Guardian's position of supervision were the children should remain in their family home. And what we say, my lord, is that that is the proportionate approach to take, where you have a non-subject child making these allegations and where there are significant evidential difficulties in those allegations being proved to the civil standard.
Well, okay, various points in that. But if the allegations were to be proved, do you accept that the care plan would be completely different?
My lord, I would have to accept that. We say, from Mr. M's perspective, that if this case were in its first year, the balance of Mr. M's position might be struck differently, the desire to ensure that his name was cleared. It's not that Mr. M has any concerns about the outcome of a fact finding. It is that the process and the delay, where we are in a case that is about to enter its third year in March, is corrosive to the children. He has been out of the home for over 6 months. He has missed significant periods of time with his youngest child, child F, and with the other children. And so when he is striking the balance for the position he put to the court, which was that there shouldn't be a fact finding, delay was a weighty factor for him, and it outweighed the desire to clear his name. Were the court to order that a fact finding must take place, then the solace for Mr. M would be the opportunity to clear his name.
Can you help me with the term you use, safety plan? I'm sure my lord know the answer to this, but what is the effect in law of a safety plan?
The effect in law of the safety plan is quite limited. It is not. It's effectively, it could be formulated into a written agreement between the parents and the local authority. Such agreements are regularly entered into in families who have involvement with the local authority. At present, the safety plan is a proposal discussed between mother, Mr. M, with the assistance of the expert from Phoenix Futures, Mr. Lowe. That safety plan could be tested by the local authority and the Guardian as to its rigour at the final hearing that is currently listed, and if parts of it needed to form conditions or any restrictions on Mr. M's parental responsibility, then there are legal structures available that could deal with that way of prohibited steps and so forth. But the most likely outcome would be a written agreement. Turning then, my lords, my lady, to if there were no findings, but there was not a fact-finding hearing, so these allegations remained with the status of unproven allegations. That was dealt with by the judge. It's at paragraphs 32 and 33 in his judgment. He records that it's common for final hearings to take place where there are concerns and allegations which have not been determined by the court, and the court has to make a decision knowing that those allegations are there.
Is it common for final hearings to take place where there are concerns and allegations about the very central issue in play? The risk of sexual abuse. I'm not sure I'm in a position
as an advocate rather than as a judge or as a senior judge to give you an answer to that, my lady. Certainly this judge was fully aware of what the issues in this case were. He knew that sexual risk was a key issue in this case. He refers to it in paragraph 6. He gives a summary of the threshold findings in Re HW from His Honour Judge McPhee, and no criticism is made of the summary that His Honour Judge Clarke makes of His Honour Judge McPhee's findings. He records at paragraph 8 that those findings stand, and then, if not quite in the same breath, at least perhaps in the same continued conversation, at paragraph 10, a few moments later, he deals with Child G's allegations. He does not in turn say that Child G's allegations are the same issue in terms of sexual risk, because he doesn't need to. It's quite obvious. Things that are common to counsel and common to the judge in the courtroom do not necessarily need to be spelt out, particularly in an extempore judgment. But having set out the threshold and having set out the findings that are sought by the local authority, it's not necessary for him to confirm that those are the same for this court to be clear that he had them in mind. As I say, within moments he goes from recording what the risks from the threshold found back in November 2020 in this case are, to within moments recording what the allegations of Child G are. It's very clear he had in mind that those allegations are of the same nature in terms of being about
My
sexual
lords
abuse.
may well be ahead of me on this, but just in practical terms, look at the last sentence of paragraph 33. Any recommendations will have to be on the basis that an allegation has been made, but it's not been proven. So in the real world, Mr. Lowe and everybody else in the court has to make these really important decisions on the basis that allegations of extremely serious sexual abuse have been made against Mr. M, but not proven.
Yes, and Mr. Lowe, who is the expert assessor, who was agreed by all parties, instructed jointly by all parties, funded by the local authority, has not raised any concerns with that approach. That is one of the approaches that is frequent in matters of sexual abuse because of the difficulties of fact findings into historic allegations of sexual abuse.
Well,
I thought, please tell me if I'm wrong, but I thought that at fact-finding hearings, as opposed to directions hearings as to decide how the case should proceed, but at fact-finding hearings, I thought, either allegations are proved on the balance of probabilities or they're not, i.e. 49% is not enough. And I don't, although I like my lady, my attention was drawn to that last sentence. Any recommendations to the court will have to be on the basis, etc. But what's the court supposed to do about it?
Well, my lord, that is a pragmatic reality of care proceedings where there are often...
let's just spell it out. The consequence here is that if an allegation is not proved, it is treated as not having happened or not being, or it's ignored. That's the binary system, which there's a danger of a sort of slippery middle ground in that sentence, isn't there? I mean, Lord Hoffman is perfectly clear about this in Read B.
But that
Paragraph
is in relation
2.
to findings.
Judges remind themselves about it in every...
So is that why you ignore it?
You ignore it. If a finding's not made, it's ignored
It is
when assessing a likelihood of future harm.
It is for the purpose of the court decision. For Mr. Lowe's report, he is entitled to take into account the allegations there, and he's had those discussions with it. But of course, the court has to take the binary approach of proven or not proven.
Well, then you've got the danger is that Mr. Lowe is making recommendations on a different basis from the basis which the court is proceeding.
But on a
I
more
mean, of course, this does cause problems in cases where findings are not made, which the expert is aware of. But the expert has to proceed on the basis they are not true. That is how experts have to proceed.
I tried to run that point in the first Court of Appeal, RW. I'm afraid we don't have that in the bundle. But the judgment was that Dr. Friedman, who is the evidence the expert in that case, was entitled to take into account concerns. I can find that in the judgment at the trial and send it up.
Okay. Of course, there will be cases where the matters have not been litigated at all.
Yes. And that would be
that's
the status
true.
of these
That is
allegations
true.
if we didn't have
But do you think that applies to allegations as serious as this? That approach is appropriate? In your case, it is.
In this case, the balance that is being struck is not simply the seriousness of the allegations, but also the plausibility of them.
Right, you're coming on to that point now.
Yes.
Wait, is that point a factor identified in any of the checklists? Mr. Justice McFarlane, as he then was, Lord Justice Peter Jackson, or even, dare I ask, Mr. Justice Mostyn?
Not in terms, my lord. I would put it, as I did in my skeleton argument, that it goes over a number of factors in terms of the evidential result and the justice of the case. The evidential result is probably the neatest place to fit it. But
I'm not quite clear what evidential result
well,
means.
no, that isn't set out. And so what we read into it, of course, my lords, my lady will be able to do far better than I will. But what we would say is the court must have in mind, is this process going to achieve anything? Because it is going to be, in this instant case, a process that causes significant delay, significant cost, significant harm to the children through that delay, which is accepted by all parties. And so when you are making that balance, the evidential result whether or not it will result in meaningful findings is
But
a
that
relevant
assumes
factor.
that it's only an exercise of any worth if the allegations are proven. But surely the exercise is just as much worth if the allegations are not proven. Because the court then has the proper platform upon which to make its final recommendation.
And the
make
experts.
decisions.
And the experts.
So it's a result both ways.
My lady, we're often in the grey area in between, of course, those two outcomes.
Because on a
The
fact
court
find, a
says-
judge will have to say yay or nay on a balance of probabilities. And that is then the way forward.
My lady, as I replied earlier, were we in year one of this case, Mr M's position on the necessity for clearing his name might be a different position.
So is it really all about delay?
It is delay balanced against the realistic prospects of these allegations being proved to a civil standard.
It's quite striking, actually, that this factor doesn't appear directly in either Mr Justice McFarlane's or Lord Justice Peter Jackson's list. But what does appear is the seriousness of the allegations.
Yes.
Now, why isn't that a lodestone for assessing whether a fact find? Well, isn't that the key point? That the seriousness of the seriousness of the allegations is obviously relevant.
It is obviously relevant, but when one assesses risk, one looks not simply at the seriousness of the allegations, but also at the likelihood. So, as the, I don't know which case it was in, a small risk of a serious allegation is something that the court is more willing to use the time and court expense to try than perhaps a greater risk of a much less serious allegation. There needs to be some kind of threshold of plausibility of allegations before the court embarks on a lengthy, expensive...
What do you say the threshold is then?
A threshold of plausibility of the allegations.
Real prospect of success. What do you mean by plausibility? Threshold of plausibility.
Yes.
So the threshold is the allegations have to have a real prospect of success.
I think in my formulation, because it's a balancing exercise the judge is undertaking, that is weighed up with all the other factors.
I'm just trying to understand what you mean by plausibility.
Yes. So the judge in this case took the view, and we say he was correct to take that view, that the likelihood of the local authority achieving findings on this was low. He then balanced the severity of the allegations, which is clearly high, with the likelihood of findings being made, which is low.
Where does he do that? Sorry, forgive me for interrupting you, Miss Bill. I'm conscious you were in the middle of a sentence, so I apologise for that. Come back to that.
Against the delay. That's in the paragraph 30, the basis of the decision, where he says, taking into account all matters, the likely impact,
Sorry, you're right.
the
I
severity
apologise
of the
again.
allegations,
Yes, it's there.
and the delay.
I just wonder what is the basis of his finding at the end of paragraph 28. Chances of the local authority proving those allegations, brackets, on the bounds of probabilities, are low. How does he know?
Because he has sufficient experience in dealing with these kinds of cases. Just looking at, I think it is his paragraph 25, he records the significant forensic challenges that would be faced by the local authority in seeking to establish findings. So what we are dealing with is one child's word with an absence of any form of corroborative evidence beyond that one child's word against the word of several others in relation to events that are said to have occurred when she was between 2 and 6 years old. And what Judge Clarke says is, paragraph 25, the court will be asked to make findings in relation to events which took place between the child being 2 and 6 years old, which have never been raised until the child was 12 years old, and one on which it would appear there is no medical evidence whatsoever. There's been no assessment as to whether child A would be capable of giving evidence within the proceedings, and also no REW assessment. Now, delay doesn't, of course, as a matter of law, preclude the findings being made, but it must be accepted that it leads to significant evidential difficulties. One example I would say, and I don't seek to use this hearing as a mini trial of the allegations, that would be entirely improper. But it's the lack of consistency even within the schedule of findings as to the timings. My lords, my lady, if you turn to B74, you see the schedule of findings.
This is a mini trial then. This is a mini trial. I mean, that's what. Sorry, I didn't want to stop you taking us there, but is there not a public interest? I mean, isn't it dangerous to pass judgment on the prospects of success on things that are so serious for so many people, including your client, to be making these sorts of statements on the basis of wholly unexplored material? Ignore the fact the judge didn't read the ABE interview. But is it right as a matter of principle that one should be passing judgment provisionally or on a loose basis on things that are so important for so many people?
The danger on the other side, if cases aren't case managed, is that every serious allegation goes to trial, my lady. So the trial judge is entrusted with that discretion, with Rule 1.4, with HDH and Oxfordshire to help them.
Sorry, anyway,
Yes, so it's a brief point, but it is one I feel worth making in terms of the timings on the schedules. The schedule appears at B74. At B75, we have the allegation number 2, which is the first allegation that relates to Mr. M, and that is dated between the years of 2012 and 2016. Child G, it should be, because for this purposes, was plied with drugs with an intent to sexually abuse. Then you go down to allegation 3, which then details the actual allegation of sexual abuse taking place between 2014 to 2016. So there's 2 years where she's on this schedule being plied with drugs with intent to sexually abuse before any sexual abuse in fact is alleged to take place. And then at allegation 5, over the page at B76, it's suggested that allegation 3, the one that was dated 2014 to 2016, took place every Monday, Wednesday and Friday over a period of 3 years, 2013 to 2016. One matter that is part of the criteria does relate to the likelihood of a fair trial, and it is perhaps a trite point to make that the likelihood of a fair trial is often, if not directly, proportionate to the amount of time that has passed since the events that are being examined. His Honour Judge Clarke was entitled to take into account that these allegations are the uncorroborated word of one person. They're unsupported, and His Honour Judge Clarke had that within the bundle by any of the other children in the home at the relevant time.
Had the judge read the ABE interview transcript? Or the... Start with that.
I am not aware how much the judge read of the ABE transcript, if at all. I didn't ask him that question, and I don't have a note of it. What I would say on that point is that he clearly read the schedule of findings because he records it accurately within his judgment. And the schedule of findings sets out in detail the allegations. So the parts that a judge would be highlighting when they read through the ABE are in fact there for him in the schedule.
But if the judge is going to make a comment on the prospects of success, if he's going to make a comment on it, doesn't he have to look at the evidence, not just the schedule?
He looks at the overall picture of the case. What he does is he looks at the fact that this is unsupported by medical evidence, that is accepted by all parties, and that is not a concerning point, we say, as the Guardian says, but a point that's borne out of the nature of the allegations. If he made that point when a child had alleged limited contact sexual abuse, digital penetration, those types of abuse, and the judge was saying, well, there's no medical evidence, then the Guardian's concerns would be entirely valid. But what this child is alleging is stabs to the genitalia, insertion of hard plastic objects. For the judge to be concerned that without medical evidence that would be a difficult evidential point, is not unreasonable of him.
Well, this is a case where there simply, it is said, wasn't any medical evidence either way. Is that right?
No, what we have, and what the judge was aware of at the time, was that there was a child protection medical in 2016, which did not show any form of relevant injury.
Is that in the papers?
No, my lords, at that point, the only person who had seen that child protection medical was Miss Beer. No one else, including the judge, had seen that document.
All right.
But going back to the ABE interview, it seems to me, reading the judge's judgment, he hadn't read it. He certainly doesn't refer to it except the beginning of 26. He says the local authorities say they've read the ABE interview and they believe it. I mean, if he had said, I've read the ABE interview, in particular what might be called the freestyle part of it, where the child is giving a narrative, say pages B28, B31. If he said, I've read it, it's manifestly incredible. From my long experience, I know that a child saying this sort of thing in these circumstances, in relation to events which took place when she was between 2 and 6 years old, is likely to be cross-examined into the ground and disbelieved, and so we better put a stop to it now. That would be one thing, but he doesn't make any reference. He just says at the beginning of 25, almost as a point of principle, that given that the child said nothing till she was 12, and given that it took place, if it did, between 2 and 6 years ago, and there's no medical evidence, and there's apparently no corroboration, there's no case to answer.
My lord,
That's what it comes to, isn't it?
just as a point of fact, not between 2 and 6 years ago, but when the child was 2.
Sorry,
between 2 and
when
6
the child was
So
between 2 and 6.
10 years ago.
Yes. Yeah.
Significantly at the time. My lord, I say that is appropriate for a case management decision. The ABE interview is 1 hour and 48 minutes long. The hearing was listed for an hour. The local authority did not stop the hearing or invite the judge to stop the hearing to go and watch the ABE interview before making this decision. They did not invite the judge to, on understanding that he hadn't read the transcript, there was no invitation to the judge to pause and not deliver a judgment until that had been done. And counsel do that on occasion. They say to a court, particularly a circuit judge engaged with care proceedings, that they would be concerned about a decision being reached without a particular piece of evidence being looked at.
So you maintain that it was appropriate for the judge to say that the possibilities, if it was appropriate for him to assess the prospects of success, he was entitled to conclude that the possibility of the allegations being proved was low, having read the schedule of findings and in the light of the passage of time and the absence of medical evidence. Those 3 factors alone.
No, not entirely, my lord. In terms of likelihood, there are 3 strands to the issue of likelihood.
Likelihood of what?
Likelihood of findings being able to be properly
Thank you.
made. The first strand of that is the inherent unlikelihood of the allegations of this child, given the level of social work involvement with the child and her family at the relevant time. Not all sexual abuse, it's entirely accepted, leads to visible physical injury, but, my lords, my lady, the allegations that this child makes in terms of stabs to the genitalia, hard plastic objects, were not picked up in child protection medicals, of which the court was aware that there had been one in 2016. We are now aware that there have been at least 2 child protection medicals in the relevant period. This was a child who was the subject of care proceedings and child protection plans for a large part, if not all, of the period covered by her allegations. There is a lack of corroboration where there would be expected to be corroboration by children living in the same home as child G at the same time, and they've been interviewed by the police. Those notes are in the court bundle. They clearly have no loyalty to Mr. M, but they make no allegations of a sexual nature and do not support child G's account. Mr M, of course, cannot say whether or not this child was ever subject to any form of child abuse. His position is clear that he was never party to any such abuse, and the position on likelihood as put to His Honour Judge Clarke, and it's set out in the position statement that was handed to the judge, or emailed to the judge in advance of that hearing, is that Mr Nevison wasn't available to be involved, and this local authority, having their institutional knowledge, the awareness of that, because they have been heavily involved with Mr mother's family, the family of child G. They were aware that Mr M was working full time. They were aware that he was involved in the pick-ups and drop-offs of mother's children, the subject children at that time. They undertook a parenting assessment of him.
Was all this before the judge?
The documents were not before the bundle, but the submissions were made to the judge by myself on the same lines as set out in the position statement for the judge that day, and made to you. He hadn't seen the children that he had jointly with child G's mother for a significant period of time before the parenting assessment, and that was one of the issues within the parenting assessment, that the older children, child G's half maternal siblings, were rather cross with Mr M for effectively, as they saw it, choosing mother's children over them. So there is abundant evidence on the ground that the local authority who are seeking to pursue these findings have, that show that Mr M just wasn't realistically available to be spending half a day, Monday, Wednesday and Friday every week for 3 years,
But this,
abusing child G.
and one can argue it the other way, can't one? And all sorts of arguments that could be raised. I'm just looking at Miss Ansell's updating statement, where the local authority makes the assessment that the pre-assessment interview suggests the allegations may well be an honest recollection.
That appears, my lady,
And that local authority fully aware of the background of all of this, and that's an expert's assessment, senior social worker, etc., etc.
Madam, what we say in relation to that is that this is a local authority that is effectively suffering from institutional amnesia, because, as we say, they have within their historic records contemporary documents which show what was going on within the families of Mr M and child G at that time. She was subject to a child protection plan. There were care proceedings ongoing. There were announced and unannounced visits. There's no reference to Mr M ever having been found at child G's home. There is, in fact, as we say, the parenting assessment that shows that it was very difficult for contact to be arranged. The local authority was also fully aware of the relationship between the adults involved being a deeply acrimonious one. So the relationship of Mr M and child G's parents, child G's father and Mr M couldn't stand each other. There's an allegation that Mr M had thrown coffee at child G's father, and he did not go to the home following the police being called in January 2015.
So, well, clearly you've got a number of points which, on a full hearing, would be relevant to determine whether the allegations are true. But on the other side of the coin, there are a number of points which can be made about the allegations. As my Lord has already alluded to the free narrative element of the ABE interviews. We've been shown the document by Ms. Mears, the initial assessments. This is something which requires detailed analysis before any assessment can be made as to about the truthfulness, isn't it?
My Lord, we say that the court has to look at that proportionately, and that's what His Honour Judge Clarke did. He looked at the overall shape of the case, at the fact that this is a case that was approaching its third birthday, that there was a risk that child C would reach majority within care proceedings, and of course we know that child F has been born and lived her entire life within care proceedings. It was accepted by all advocates at that hearing that His Honour Judge Clarke was entitled to take into account likelihood. as part of that balancing exercise. I would just very briefly, as a last point in terms of likelihood, draw your attention to B140, the police record, where they deal with the allegation. They record it in the Home Office statistics as N100/2, allegation of rape with credible evidence to the contrary exists.
Sorry, whereabouts you read on 140?
It is the top entry in the middle block DDM review, where it says reclassified.
Sorry.
140.
Oh, sorry, it's B141. I apologise. I think
Oh yes,
I read
the
up
DDM
rather than read
review.
down when doing the page references. DDM review reclassified, and the N100/2 is a Home Office reference for statistical purposes, and it's recorded by the police as an allegation of rape in which credible evidence to the contrary exists.
Is that before or after the AD interview?
Before.
I believe that is before.
It
the
looks as
AD
though it's
interview.
before.
This is less than a fortnight after the Supreme Court decision, and about 3 months before the ABE interview.
Right.
It's not my only point on likelihood, but I had it in my notes and I wanted to make
Yes.
sure I'd got
Yes.
that one in as well, my lords. Because we say that it being common ground by the advocates that Clarke could take likelihood into account, it was proper that he did, because it ties into the question of necessity, which is in a separate paragraph now in the re-HDH, but is still the key test. And the necessity of a fact-finding must be tied in with the realistic prospects of findings being made that would inform the ultimate welfare decision. This isn't one of those cases where grasping the nettle and making findings now rather than leaving it lying for years applies with much force, because the findings sought are in relation to events that are alleged to have occurred between 10 and 6 years ago. His Honour Judge Clarke undertook a balancing exercise, and he balanced the difficult, lengthy and expensive process against the likelihood that that would result in an evidential result helpful to the court. This is a resource-heavy case already, and HDH does set out that the court can consider not only the resources used on that case, but then the absence of those resources for other cases, where His Honour Judge Clarke, having gone through the 1.14, looked at the implications for other cases, and this court can also have in mind those other families and other children whose justice would be delayed by the resources being poured into this case in pursuit of these findings. My lords, my ladies, I'd sort of end where I started, that this is a case management decision by an experienced judge exercising a discretion. And for that discretion to be meaningful, the court must have the ability to say no to a fact finding where there are serious allegations, as well as to say yes. He did so properly after having considered the gravity of the allegations. He sets out the allegations as they are in the schedule in terms. And the question for this court is not whether a judge on a different day, or indeed 3 judges on a different day, would come to the same conclusion. The question is the exercise of his discretion wrong? And the future conduct of this case, if His Honour Judge Clarke's case management decision is upheld, would have final decisions being made for the subject children within the next 2 weeks. Mr. Lowe has reported. The local authority have chosen not to challenge that report, but instead, through final evidence, are seeking no order, the dispute would then potentially be on whether there was a supervision order as recommended by the guardian and in all likelihood being accepted by the parents were the court to feel so minded. The parents' evidence is due today and the guardian, we would, because the issues have now reduced and we do not need the full 10 days, we would agree between us and submit a consent order to the court for the court to consider an extension of time for the guardian to file their final report in the early part of next week with a view to having the final hearing towards the later end of those 10 days so that we don't use up court time unnecessarily. That would mean that the final hearing could conclude by the 10th of February, ending this case before its 3rd anniversary.
I would have thought if it's a submissions, it could be decided on submissions if this point is.
Yes.
Isn't it? I mean,
it's highly unlikely to be significantly controversial in terms of any evidence. If the local authority maintained that they seek no order, the parents would both be willing to submit to a supervision order being made, and the guardian positively advances a supervision order, then it's a clear case for submissions.
resolvable at IRH.
What?
The President would want me to stress.
This is why, my lords, my lady, I give the somewhat unusual thought exercise almost in the final paragraph of the skeleton argument. If, when the case had been remitted back from the Supreme Court, the pragmatic approach had been taken that supervision orders met the justice of the case, and then these allegations had emerged afterwards.
Counterfactual.
I appreciate, my lord, that it is counterfactual, but I do say it's a relevant counterfactual thought exercise in this case, because we're looking at what would the appropriate response of a local authority be in that situation. We say it wouldn't be to bring the case back and seek to have those as threshold findings and seek to remove those children from Mr. M and mother. It would be what's happening on the ground.
I don't want to take up time, but let's just follow that through. Supposing the case had, as you say, had resolved by agreement on a supervision order basis, before the allegations by Child G had come to light, the local authority would then have possibly, probably, I don't know, started fresh care proceedings on the basis of these allegations.
Well, we say the allegations are not sufficiently cogent if the local authority recovers from its institutional amnesia and properly looks at them. For the proper action of the local authority in that case, where it's a non-subject child, the subject children have never made any such allegations. I
may say this in response to your otherwise deceptively attractive counterfactual point. But if the local authority had done that, then these new fresh care proceedings would have got off the ground and they wouldn't have been struck out summarily, would they?
Well, in front of His Honour Judge Clarke, my lord, they might well have been, for the same reasons. That not the reasons in terms of delay, but effectively the abusive process of bringing the family straight after supervision orders.
Well, that gets us into more dangerous.
Well, it couldn't be an abusive process if the allegations were new. But you say that the judge would have been entitled to take the same approach to fresh care proceedings as he did in these far from fresh proceedings, and to say that for the reasons he gave in paragraph 28, the chances of the local authority proving the allegations were low, and therefore he would stop the care proceedings before they got to a full fact-finding hearing.
My lord, what I say actually goes back a few steps. I say that the local authority in that situation wouldn't actually issue, because when they went through their internal processes and considered, rather than already being within care proceedings and seeking to effectively add them to the mix, non-subject child allegations, even of a serious nature, would not directly and obviously lead to the reissuing of care proceedings. What I say they would have led to would, of course, have been discussions within the local authority, would have been potentially legal planning meetings, and would have been what happened on the ground in this case, safety plans being put in place, and the local authority working with the parents under a supervision order. Because these allegations are precisely that, they are allegations. So on that counterfactual, I'd appreciate it's not always an attractive way to deal with it, but this is such an unusual case in some ways that it is worth having pause for thought. What would have happened? The children would have remained with Mother and Mr. M in all likelihood. A court would be unlikely to have removed them at an interim care order hearing on the basis of these allegations, even if the local authority had determined to issue. We have the expert assessment in this case and the safety plan that has been gone through with the expert and that can be finessed and altered if necessary with the input of the social worker and the guardian. So, my lords, we say that Judge Clarke came to a reasoned decision and he is entitled for that decision to be respected by this court, and we ask for it to be upheld. Are there any specific points that I can attempt to the best of my ability to assist you with?
No, thank you very much.
My lords, my lady, you'll appreciate that Mother doesn't take any position in respect of the appeal, save that she's desperately worried about the delay and the corrosive effect on her children. As we approach the 3rd anniversary of the issuing of these proceedings, those relating to an allegation and findings that relate to November 2019, so already 3 years ago, she finds and the children find the continued intrusive and rather demanding expectations of being within proceedings with the children at home, wearing and corrosive. And it's on that basis that she feels and would wish for these proceedings to come to a conclusion in the next 2 weeks. It's accepted by the local authority in their final evidence that the children have been safe in their mother's care since the index incident in November 2019. And I don't think it's controversial that there have been no allegations made by any of the subject children against Mr. M since he moved into their home in 2014. His older children, who lived with non-subject child G, have been spoken to by the police, and summaries of their interviews appear at B230, 3B231 for adult female children, and also at B237 to 238, his still minor 5th child, who's a male. The subject children, of course, not F, because she's too little, but C, D, and E have also spoken to the police. That's at 236.
Sorry, forgive me. Could you just give me those page references again? I miswritten down.
Of course.
The other children, B22.
Sorry, the adult female children.
Yes.
B230
to 1.
B, yes, indeed.
And then 237 to 8.
238 is the still minor male child who remains in the care of this local authority. And then the older 3 subject children, B236 to 237. They are just summaries. They have lived with Mr. M for 8 years, those 3 subject children, E being very young when he started his relationship with Mother, and the 4 adult female children of Mr. M, 3 of the 4 lived with non-subject child G during the period that relate to her allegations.
So what does this go to?
The mother's position is that on the ground, her children, save the findings which were made by her and His Honour Judge McPhee, which Mother didn't contest at the time, save the timing of when it was she who raised the alarm about what her older child B had said she had seen A do. That can't be forgotten. It was she who raised the alarm with this local authority. There was some dispute as to the timing of that, but other than that, she did not contest the allegations, and she did not seek to disturb them in either her appeal to this court or to the Supreme Court. And other than that incident, these children have been safe in her care. And that's relevant when considering the issue of likelihood. Of course, she takes a very careful approach in respect of the truth or not of the allegations. She can't. They don't relate to her, and she is the only one caring for the children.
When you say likelihood, what do you mean? Likelihood of what?
Likelihood in respect of His Honour Judge Clarke's exercise.
You mean low possibility?
Indeed. In respect of the issue of necessity, I agree with my lord that it is striking that that word is missing from all of the judgments which are before this court. And I agree that those are the relevant: HDH, Lincolnshire and C&B, Oxfordshire County Council, D&P, REW, REL and REP. But in my submission, I make this merely as an observation. The issue of necessity and proportionality run through the very core of every decision which family courts make, not just in relation to whether a fact-finding should be held or not, but orders in respect of children. Necessity is a principle which we apply in many circumstances, and as an example, I suggest that in Lord Justice Jackson's decision of HDH, which is at C3, paragraph 3, decisions about the scope of fact-finding are core case management decisions with particular consequences for the length and cost of proceedings, the impact of litigation on parties and other, and the allocation of court time. They arise in private law proceedings when a court is considering whether there should be a fact-finding hearing in relation to a disputed allegation of domestic violence under Practice Direction 12J, and in public law proceedings when the court is considering whether it should investigate a fact alleged as forming part of threshold or as being relevant to a welfare decision. And that's what we're dealing with here. This is not a threshold issue. Threshold is so far in the past and accepted by both mother and Mr. M. But the local authority puts their case on the basis of being relevant to the welfare decision. That the court, in circumstances when making case management decisions, must consider, in my submission, likelihood, without hearing evidence and without undertaking a fact-finding decision. And those are decisions which the courts make every day. And necessity, in my submission, is absent from the criteria in the case law.
Sorry, forgive me for interrupting.
Of course.
You say should determine likelihood on the basis of a paper-based exercise on what's available.
Yes. I don't know what His Honour Judge Clarke read. Not only is it not apparent from his judgment, but I wasn't present at with the one hearing. I wasn't present. But I can take my lords and my lady to those elements of the bundle which were before the court at the time, which the court will be aware of was raised by my learned friend from Mr. M in her skeleton argument, which appears in the bundle, about the inconsistencies in the account given by child G. And I say this as an observation, asking my lords and my lady to keep mother's position firmly in mind. But there are inconsistencies between her first account given to her social worker in what would appear to be a care home, the account given to the police by that worker the next day on the 24th of June 22, in the pre-ABE assessment on the 5th of September, and in the ABE itself.
I mean, none of these points are made in the judgment.
No.
Sounds like a respondent's notice point, but you're adopting a neutral position.
I am just trying to assist the court in identifying those factors which are the evidence which was before the court at the time that His Honour made his decision. And what I would say is that my lords and my lady will be acutely aware of the pressures on the family division. and on circuit judges in particular, district judges as well. In a 1-hour hearing, there is a limit as to what a judge is able to achieve and able to record. It is a difficulty which we face, and I cannot see that anyone invited His Honour to repair any omission in his judgment. That would be the first protocol.
Well, you're saying there should have been clarification, are you, of a case management decision?
My Lords, can I just...
Of course.
Because I, of course, was the advocate for that hearing.
Yeah.
At the end of the hearing, and we've been given a very clear timescale of the hearing, His Honour Judge Clarke had been clear we only had a limited time available. My social workers had to go off to deal with an emergency matter, and so I wasn't able to take instructions from them at that point. And so His Honour Judge Clarke had said that there was time for me to be able to go away and take instructions and come back if required. And so that's why he wasn't asked to deal with any other matters.
All right. I mean,
It's not a criticism.
I've spoken elsewhere of my concern about the excessive requests for clarification of judgment, which seems to be happening more and more frequently, and add to the pressures on the judge
Indeed.
that Ms. Grieve was talking about.
Thank you.
So we have a 10-day hearing for a case when the issue is whether there should be a supervision order, and an hour hearing for something which is manifestly insufficient.
Yes.
on your argument.
I don't think anyone anticipates that if this appeal is refused, that 10 days would be in any way necessary.
No.
It's been in the contemplation of the parties that there would be.
Well, I hope Judge Favretschka and the team at Watford have been told about this, because
I don't know.
anyway,
That I
that's
don't know. No. And
blocking the diary.
the only other evidential point which I wish to raise with my lords and my lady, which would have been before His Honour Judge Carr, is that of the intermediary assessment, which I ask you to consider with some care as B149 to B154, where it describes the characteristics of child G. Sorry, they've given me the wrong page reference, I'm so sorry.
That's a pre-assessment.
Yes. Yes, I'm so sorry. It's the intermediate assessment is B246.
This is before the ABE interview, is it?
It is. It's the 5th of September before the AB, which I believe is the 20th of September.
Sorry, it's my fault. I've just got the wrong reference page.
It's my fault. I
No,
gave
no.
you the wrong reference, my lady. It's B246.
246. Thank
Yes.
you.
250, you're going to refer to, are you?
And
Suggestibility, etc.
Indeed. Not only that, but it's 247, poor self-worth, identifying many negative qualities in herself. 248, delayed in emotional and cognitive development. B249, unclear about what she knows and does not know. And then, indeed, highly suggestible and would quickly capitulate to another's view. And there is also the recording at B253 that her allegations arose after, this is in the arrest inquiries following on from that assessment, and there doesn't seem to be a date attached to it, that she received a letter after a child looked after review disclosing to her the background reasons why she was in care. And after she read that letter, or it was read to her, it's not clear, she became unsettled, and then a few days later made these allegations. So I accept on behalf of Mother that findings in relation to these allegations would be relevant. But I do say that the court, and everyone agreed at the time, is able to consider likelihood of findings being made. The finding which the court made was that it was unlikely given the evidence and the allegations themselves. And what was before the court were these inconsistencies. I agree with my learned friend in respect of case management decision submissions. And I say that in respect of His Honour Judge Clarke's judgment, the most important paragraphs are those 10, where he's aware of the allegations, despite not having viewed the ABE, and his consideration of the likelihood at paragraph 28. I don't know whether I can assist my lords, my lady, any further, given the position that Mother takes. It's just struck me during the submissions of those points may be helpful.
Thank you very much.
I'm grateful.
Thank you. Ms. Batchelor.
My lords, can I just respond in relation to Miss Beer's counterfactual argument very briefly, because I don't accept on behalf of the local authority that if these allegations had come around after conclusion of proceedings, children at home with both parents, under an order or not under an order, perhaps a written agreement, the local authority would not have come back into proceedings, given that Mr. M would have been, at that point, the protective factor. If he was going to be at home with the children, it seems to me that the local authority would be as equally concerned at that point as they were in July when we became aware of the allegations. My lords and lady, we know that Judge Clarke didn't read or see the ABE because he told us at the beginning of the hearing. I had referred him to it. I didn't ask him to view it because he had been very clear that we had a very short period in which to deal with the matter, and he was going to deal with it, having refused my application to adjourn to see if Judge Newton would take the matter. And the other point that I just wanted to make in relation to the issue of likelihood and whether a judge should be considering that point. All courts dealing with these issues and advocates are faced with having to analyse the evidence before it. Whether it's a local authority preparing a schedule or whether it's parents, advocates preparing schedules to put before the court in terms of findings that they see. What we don't do is conduct mini trials ourselves. And that is not what any of the judges were being asked to do. Certainly Judge Clarke should not have been carrying out his own mini trial. The information and evidence that was put before him, and it's information rather than evidence at that point, by Miss Beer on behalf of Mr. M, were matters that she was aware of through her client, because of course he had access to and he was involved in previous proceedings, so he knew of some inconsistencies of the background. That was not what the local authority were fully aware of. We have a non-subject child G who has a very different team working with her. She's under the looked after team. These subject children have a different team in terms of proceedings. And so to try and ask any local authority or anybody putting allegations before the court to conduct their own mini trial and make their own analysis and observations, it is circumventing the point about the findings. Is there anything else that I can assist you on?
Thank you.
Sorry,
Miss Muse, but
just a point of clarification, my lord, my lady. The children's guardian is out of the jurisdiction, so she doesn't know what the local authority final care plan is, and she. It's being said the guardian would ask for a supervision order. We think, in all likelihood, the guardian will absolutely say these children should not be left at home without any order. But we can't say absolutely that she will be recommending a supervision.
I mean, it could be a care order.
Well, my lord, I don't know what the guardian is.
It could be a care order.
It could be.
Okay, all right.
What I can say is the Guardian is desperately worried about all of the children, but it's not right to say that she would be recommending a supervision order, because we don't know.
Right. Thank you very much. We're grateful to all of you. We will try at least to announce our decision today, because you've all got to know whether this hearing, whether it's 10 days or less, is going to go ahead in the very near future and on what basis. We will try, if we can, to come back and give our decision at 10 to 1. But if we can't, we'll send word that you should all go away till 2 o'clock or something like that.
Yes.
We'll see what we can do.
Thank you.
Thank you.